have been sought and shouldn't be clearly. That man who was sacked. Beloved day in court. Thank you very much.
Sorry, Your Honor, do we have a right to respond? Of course. There are any objections? Mr. Owiti, together with who?
I'll just go alone. Most
I not specified.
Yes. Yeah, I'll start with the jurisdictional issue that has been raised by counsel, especially the very learned Dr. Amino, as whether or not this court properly has jurisdiction to entertain these charges. And whether or not the Director of Public Prosecutions had power to institute these charges.
Yes.
And that is related to reference to Article 181 and 182 of the Constitution relating to vacancy in the office of a county governor in Kenya. I believe, I haven't made reference, but I believe that's the position. In brief responses, this court's jurisdiction to entertain anti-corruption matters is provided for under Section 4 of the Anti-Corruption and Economic Crimes Act. So that's a simple answer. Section 4 of the ASEC. ASEC is a law. Point of law is ASEC. So this court has jurisdiction. The Director of Public Prosecutions is vested with power to institute criminal proceedings against anyone before any court other than a court martial, Article 157, 6A of the Constitution. Allow me to make two corrections. My very good friend, Mr. Degwa, tells the court that there is no nexus between the affidavit and the charges, and if your record confirms what I also heard, that there is no such charge as conflict of interest, which is count number 1. I don't know whether counsel read the charge sheet. Count number 1 is conflict of interest. And not just that. Count number 2. How could he have gotten that wrong? Conflict of interest. And it does not only mislead you on that. He says that the prosecution, on behalf of the prosecution, no law has been pleaded, no evidence has been produced, no case law has been referred to. I refer to Tom Chomley, case law in Kenya. I quoted Article 49(1)H. I quoted Section 123A. These are laws in Kenya. The second correction, Your Honor, my learned senior, Mr. Masharia, if I don't get that wrong, tells the court that the areas, the subject of the warrants issued on 18th of June were limited to 3, Kibomet and another one, it's on the record.
Sharia also.
Oh, Mr. Sibiu, I apologize, that's why I was not sure who's in. Your Honor, for those who have not given a copy of that warrant, it says, and any other part. Let me just read that so that I get it correct, so that I don't mislead the court. The warrants have been referred to, just below the areas listed. this and any other office, business, and residential premises wherever they may be situated within the Republic, unless we are reading different ones. So that even the search in Trans Nzoia was by law, was sanctioned by law. But then there's the related question as to whether the warrants issued could also be the basis of an arrest. That is the question asked by my learned friend and teacher, Mr. Echesa. Your Honor, this is a cognizable offense. Mr. Smith taught me this way back in 2011. For cognizable offenses, you don't need a warrant. So the arrest was proper by law. So the arrest was proper. The searches were proper. The defense has attempted to repudiate the charge sheet. Although they have gone around the corners, they're not coming strongly about it. But they seem to be questioning the propriety of the charge sheet, or rather the charges. There was no attempt to invite this court under section 895 of the Criminal Procedure Code to reject the charges. Plea was taken. As it is, the charges are proper, including the particulars. And in compliance against with section 214 of the CPC. But there is a smaller issue about the amounts. This is related to the charge as well. That a whole governor should not have been brought before you for amounts about 1 million or 2 million. You know, I agree with Mr. Ochieno that this court may not interpret but can apply. In the application of the constitutional provisions, Article 27, Sub-Article 4 obligates this court to ensure and promote an equal application of the law to everyone. Equal application of the law. Article 27, Sub-Article 4 of the Constitution. Before this court, you know, I've never had the privilege of appearing before you. And I'm sure my colleagues who have here have brought people with cases of soliciting a bribe. Some of them up to 3,000 or 5,000. They are Kenyans as well. So that the amount, the basis of the charge cannot be the basis to question whether or not the charges are proper or whether or not compelling reasons exist. I can confirm to this court that's a factual issue, but I can confirm to the court that the DPP, in fact, ascertained and satisfied himself that there were charges properly on the basis of which he could institute these proceedings before you. Now, in respect of Article 181 and 182 of the Constitution, we are not attempting to impeach the governor. The DPP has no such powers, legally or factually. But more importantly, whether or not denial of bail would amount to removal of a governor has been answered by the Supreme Court of the land in the case of Ferdinand Waititu versus Republic.
You know, he's raising new facts that were not part of address to the court.
That's a question of law, Senior.
No, it never came up, Your Honor. We perhaps need a very clear ruling on that particular objection, because that never arose in our submissions.
Dr. Aminu raised Article 181 and 182 and said that removal can only be by other parties, not the DPP of this court. That's what I'm answering. And again, because Mr. Ndegwa did not even know that conflict of interest was count one, he may have missed this as well. I withdraw.
If you have withdrawn, I wanted to clarify, but I scored me Dr. Minute saying something else.
Yes. It's going to mislead, unfortunately, it's going to mislead the court.
Now that he has withdrawn, there is no need to clarify that point.
So, Your Honor, I further
scored him differently,
yes.
So now that you withdraw that point, I will not.
Most of like, I've also withdrawn the arguments on 181 to I scored it differently. That's why I've withdrawn. Your Honor, back to the question of bond as I conclude. Page 19 of the Judiciary Bail and Bond Guidelines, at the very bottom in the footnotes, refers to a case of, let me just get it, Republic versus John Kahindi and two others, reported in the Kenya Law Report in 2010. Republic versus John Kahindi and two others, 2010 EKLR. It is at the footnotes of page 19 of the Judiciary Bail and Bond Guidelines. The import of that case, Your Honor, is that the prosecution does not need to avail an affidavit in opposition of bail. Anyone can confirm because the guidelines are available online.
The prosecution
does not need to avail an affidavit in support of an application for denial of bail. While other courts insist on it, not all courts insist on it. That's the import of that decision. It's cited at page 19 in the footnotes. The importance of that argument that you make is that even without an affidavit, compelling reasons can exist. And so that the argument by Mr. Otieno that if certain documents were removed or expanded, then there is no basis. If we can come without an affidavit, there is still basis. There's also the argument as regards saying that we are not proved. Sorry, Your Honor.
We are now on your 12 minutes.
15 minutes and I'm done, Your Honor. I underestimated my abilities. I'm sorry.
You can't admit that. No, your pace, not abilities. I'm not doubting your abilities. You underestimated your pace.
Yes, yes.
Minute.
Thank you. Your Honor, I was referring to, please Your Honor, just help me direct. What did I say last? Kindly.
Last you were attacking the challenge by Mr. Otieno.
All right, yes, thank you very much. So Mr. Otieno was of the effect that if there is no certificate under
that was concluded.
Then I can move to the next point. Your Honor, the other issue as regards bail, as I conclude, is that there is an admission from the defense, at least evidenced by Mr. Echesa and Dr. Haminwa. In Mr. Echesa's words, the first accused is a governor of a county. He is a deputy party leader, and he is not a lonely man. Verbatim, if I got it right. In the words of Dr. Haminwa,
I don't know whether Your Honor you misquoted in my presence, especially in terms of understanding.
You were not sure what you are objecting on. Is it points of law or what you say?
As in, you have quoted my statement in my presence, yes. You clearly misunderstood it, and you want to go to the next person without clarifying the question.
Sorry, Your Honor, I have not interpreted what Mr. Echesa said. I have quoted it as I captured it. So the court can confirm that he said that the first accused is the governor of a county, is a deputy party leader, and is not a known demand. I am quoting you verbatim. I may be wrong in my interpretation, but in hearing you, I can't be wrong.
Points of fact. Points of law.
I'm coming to the point of law. I'm still quoting you. You cannot be the point of law. I am coming to the point of law. Yes, I'm still quoting so that I come to the point of law. Dr. Hamura on the other hand says that the people in the first accused area were mad yesterday as a result of his arrest. Those are two admissions as to and thirdly, I am reminded that my very good friend, senior Dr. Harunubi, mentioned that monkey see, monkey do, that the people have seen and are doing. The point of law we are making is that there is a likelihood of interference with witnesses. And that the influence of the first accused is admitted by his counsel on his behalf, and that it is not far-fetched that he would interfere with witnesses and investigations. Your Honor, clause 4.9 sub-clause E of the Judiciary Bail and Bond Policy Guidelines talks about likelihood. Yes, Your Honor.
You just said you need 30 minutes.
I am done. That is my last point. 4.9 sub-clause E of the Judiciary Bail and Bond Policy Guidelines talks about likelihood. It doesn't say certainty as proposed by Mr. Nego. If there is a likelihood because of that influence, there is a compelling reason you must deny bail. And standard of proof is on a balance of probabilities. I thank you for being patient with me. I am such a mouth, and we urge you that we have established compelling reasons to deny the first accused bail. Thank you, Mr. Your Honor.
One of the points actually Honorable Jeremiah Kioni, Assessor of Council, who wished to place him on record.
It's now almost 1. Taking it So I will need a break to do a ruling on the matter. I possibly need